Good morning, I'm Father X. In these videos, in episodes 11, we're getting you ready for your child custody trial. Your goal in a custody trial is to determine the best interests of your child. You might be asking, what do I say in court to prove it's in the best interests of our child for me to be a 50-50 or primary custodial parent? In my prior episodes, 11B, 11C, and 11D, we spoke how you can testify about multiple best interest factors. Now we'll talk about child neglect or abuse, as well as the parent's alcohol and drug use. Let's get to it. Findings of child neglect or abuse. First, let's start to define neglect or abuse, and then we'll talk about your trial goals, trial strategy, and some examples from my own case. For infants, neglect can include malnourishment, not changing diapers, not bathing the child, not giving the child required medications, or not dressing them appropriately for cold weather. If you're being accused of malnourishing or not properly feeding your infant, remember that the pediatrician is the expert on whether a child is malnourished. The mother's accusation and any statements by any uninformed lawyers are not sufficient. For example, an early complaint from my ex during the court process was that our infant son was hungry after my parenting time, even though I was his primary caregiver and fed him just fine while we all lived together before court. Infants eat every 3 hours. You can feed them before dropping them off, and they're hungry again when they're with mom. That's what a baby does. It doesn't mean you didn't feed your baby. So the mother is complaining about nothing, and you should portray how she can't co-parent because of her unnecessary negative interpretations. Verbal or emotional abuse can include name-calling, degrading, or threatening a child. Even verbally insulting the other parent in front of the child can be a form of emotional abuse to that child. Physical abuse can include hitting a child with an object or your fists, kicking, or using excessive force. Sexual abuse is bad enough, but imagine when a child can't speak well enough to confirm or deny what happened. We need to protect our kids from sexual abuse, and we also need to protect our kids from the false accusations of one parent trying to get an upper hand. In cases involving this, get guidance from a pediatrician or child psychologist, somebody who knows what they're doing instead of some hack, second-rate lawyer, judge, or social worker in the court system who's trying to determine if there was sexual abuse. What's your trial strategy? It's in the worst interests of the child to be primarily raised by the parent who abuses or neglects them. Your strategy is to prove and have the court agree with you on the following two conclusions. First, because the other parent abuses or neglects the child, they should not have 50-50 or primary custody. Of course, that assumes there was abuse or neglect. Second, if the other parent falsely accused you of abusing or neglecting your child, then because they lied to manipulate the court process, they shouldn't end up with 50-50 or primary custody. And because the other parent made false statements about you abusing or neglecting your child, then they're lying to prevent you from raising your child. And this is the exact opposite of fostering a relationship between the child and the other parent, which is another best interest factor. Family court judges are notorious for ignoring false accusations and rewarding the mothers who make them. You have to assertively stress in court that the mother's false accusations make her not capable of being a 50-50 or primary parent. Why would we force the child to be primarily raised by the mother who has already proven she will constantly insult the other parent in front of the child? That would be in the worst interests of the child. What do you testify about? The questions to ask and answer are there instances of abuse or neglect by either parent? Describe them. How do you know about the abuse? Did you witness it? What happened exactly? If the other parent was abusive or neglectful, testify about what you did to protect your child. Did you take your child to the pediatrician or hospital? Did you call the police? Did you contact friends or family for help? Did you and the mother go to couples counseling? Did you change your schedule so you could be the parent to spend more time with your child instead of the other parent? A good parent would naturally protect their child. It helps to prove there was abuse or neglect if you then took actions to stop it. If 2 years later, one parent claims there was abuse but can't say they did anything about it, then the question becomes, was there really abuse? And if you're falsely accused, then what did the other parent do to stop your alleged bad behavior? If they did nothing, then testify that it's because there was no abuse or neglect, and they're just making it up now because there's a custody case. As a father, you're the underdog in a child custody case. If there are instances of abuse, testify about these in court and bring any photos, videos, medical records, or witness testimony. You can't give the mother a free pass on her bad behavior, because then you're increasing the chances she'll get primary custody and you're putting your child at risk. Assume most judges won't even consider the possibility that the mother is abusive unless you bring it up. Don't complain about petty issues, like the time your toddler fell and hit her head when the mother was 15 feet away, because toddlers fall all the time, and that's not necessarily neglect. Unless maybe the mother was 15 feet away and she was drunk or high. If there's abuse or neglect, talk about each occasion separately and clearly. Think of your accusations this way. Would an average person think this is an instance of neglect or abuse? If it is, then bring it up. If it's a pattern, then tell the judge that past behavior is the best predictor of future behavior, and we can only expect that parent to engage in more abusive or neglectful behavior as the child gets older. So why would we give that parent 50-50 or primary custody now? What is and what is not child abuse? Identifying child abuse is easy in obvious or extreme cases. The challenge comes when there's a gray area. For example, what's the difference between spanking your child versus physical abuse? Broken bones obviously indicate abuse. But are you allowed to hit your child when you discipline them? There are different opinions. What's the right answer in a custody trial? 50 states have 50 sets of laws, so learn the rules in your state. Go to your Child Protective Services website or call them anonymously. Ask them what qualifies as physical abuse versus spanking or discipline. Don't tell them your name or invite them into your life. Just privately learn what the rules are, because the judge is likely to determine abusive behavior based on the standards that Child Protective Services created for your state. For example, if the other parent spanks your child in the butt and you say this is physical abuse, but the court and Child Protective Services don't see that as abuse, then you're wasting your time and might look silly. But if one parent hits the child with a belt and doesn't think it's wrong, because that's how they were raised by their parents, but the judge and Child Protective Services think using belts is abusive, then a person admitting this can crush their own custody case. So learn the rules from Child Protective Services anonymously before you present your case to a judge. In addition, judges often defer to mandated reporters, such as pediatricians. If they report something, then a judge is more likely to take it seriously. But if a child was seen by their pediatrician and they don't report abuse, the judge is likely to think there wasn't abuse because it would have been reported by the pediatrician. This isn't an absolute rule, but consider it general guidance depending on the circumstances. In general, I found that family lawyers and judges are incompetent at differentiating between actual child abuse versus false allegations. They don't ask the right questions to figure it out. I found that when lawyers in the courtroom talk about child abuse, their argument is just that their client is innocent or the other parent is guilty. But lawyers argue like 7th graders who just joined their junior high school debate team. They often don't conduct any real analysis about whether child abuse actually exists, especially when it's a gray area and not obvious abuse. How do you introduce intelligent thought into this discussion, since your child's well-being is at stake? Go to Google and search for articles written by psychologists about child abuse and how to identify signs of abuse. If you read how psychologists view child abuse, then you'll likely become smarter than the judge and lawyers in court. And when the lawyers and judge make dumb statements, you'll be better able to challenge them. And you must be assertive and contradict them. Don't let their false statements or conclusions go unchallenged. I found that pediatricians are pretty good at knowing if there actually is child abuse or neglect, so get their input. Unfortunately, many judges will hear an allegation of abuse and then, on caution, will keep the child away from the allegedly abusive parent to avoid exposing the child to potential harm. While that sounds nice, it's actually half-baked because there are so many false allegations. When you just take the word of the accusing parent, you're also risking creating real harm to the child because they're separated from their innocent parent. So while judges will likely engage in half-baked analysis, this issue requires intelligent analysis. And the only people that can do that are probably only you and a pediatrician. Basically, somebody who cares about the actual truth. If you meet with Child Protective Services, it's best to assume these social workers are incompetent and gender biased against dads. You have to teach them what intelligent thought looks like, based on actual facts. If you're falsely accused, or if you're accusing the mother. You have to get them away from the standard stereotypes against fathers that they love to use. Be assertive, but polite. How do you disprove false allegations of abuse? There are endless scenarios that can play out. I think the best technique is, don't be defensive and don't use empty phrases like, "I'm innocent." Instead, tear apart the false allegation directly. It usually looks like this in your testimony. The facts A, B, C, and D lead to logical conclusion E, that you are not an abuser. When you state the facts, state all the facts involving the incident they claim is abuse, and specifically say that the obvious logical conclusion to these facts is that you are not an abuser. And then you attack the false accuser's statements and logic. Somebody falsely accusing you will often make the same mistake, whether it's a judge, the mother or her lawyer, the guardian ad litem, or Child Protective Services. When they make false allegations, their standard mistake is that fact A plus false statement B equals incorrect conclusion F. So you point out that fact A is true, then you highlight exactly how statement B is false, and you highlight that they're ignoring fact C that you testified about, which shows your innocence. And then you talk about how their conclusion F, that you're abusive, is illogical based on the actual facts. Basically, you're reconciling the false allegation with the reality and holding them side by side for everybody to see so they can't hide from it or talk in circles. You're probably the only one who's going to show them how they're wrong. Do it assertively but politely. Try to keep a level head and think clearly, instead of getting swept up in the drama of false allegations. Luckily, in my case, the allegations of child abuse or neglect were minor compared to the more serious issues other parents deal with. When my son was 1 year old, he came home with a scar on his head that was mostly healed. His mother wouldn't say anything about what happened, even when I asked her. My automatic instinct was that she lost her temper and hit him in the head with something, maybe because he was crying. But he wasn't old enough to tell me what happened. I could have made a big deal about it and called Child Protective Services, but I didn't, because I just wasn't sure, and I know that sometimes toddlers just fall. Up until that point, the mother was making false accusations against me for domestic violence, but I was making real accusations about her violence. I already had enough evidence to justify that she should not be the primary custodial parent, and I didn't want to make false allegations against her because that would discredit my true allegations. I was trying to show a difference between me and her, in that she makes false allegations, but I only speak the truth. A year later, during trial, the mother's witness, one of her friends, testified that they were in the park together and our son hit his head on a park bench while running around. If I had made an accusation, it would have been proven false, so I'm glad I didn't make one. As a second example in my case, we started the forensic evaluation about 7 months into the family court process. By this point, I had already made many allegations about the mother's violence. Strategically, the mother needed to make me look like an abusive monster for her to keep custody. So the mother told the forensic evaluator that I watched pornographic videos on my computer with my son, and this would have been when my son was 3 to 9 months old. It was a ridiculous and new allegation. I didn't even watch porn, and if I did watch that stuff, why would I watch it with my baby on my lap for him to also watch? It was absurd, and I told the forensic evaluator it was absurd. Luckily, the forensic psychologist agreed with me, And then, instead of panicking about this false allegation, I laughed to myself because I realized the mother was destroying her own custody case by making these absurd false allegations. She was showing her true colors. Instead of panicking, it's better to package all of the false accusations together in your testimony to show the pattern of the mother making false allegations to get custody. In my testimony, the phrase I kept using was, "There's what the mother says, and then there's reality." Over my 28 hours of testimony, I successfully drilled that idea into my judge's head. Let's talk about the parent's alcohol and drug use. Alcohol and drug use becomes an issue when it prevents a parent from adequately taking care of their child. If a parent has a beer after work on Tuesday night or a glass of wine on Saturday afternoon, that's not a big deal. If the mother attacks you on this, try to make her look petty. And you shouldn't attack her for drinking occasionally, because then you would look petty. Only discuss this if it creates serious issues with parenting. You can prepare testimony around these topics. Describe your current and prior history of drug and alcohol use. Include any treatment for drug or alcohol abuse. Describe the mother's current and prior history of drug and alcohol use. Again, include any medical treatment for drug or alcohol abuse. Does either parent engage in alcohol or drug use that hurts their ability to care for your child? Describe incidents that demonstrate this. How is your child neglected or put at risk? Is the other parent a mean or abusive drunk? Describe their actions. What are your concerns about the other parent's alcohol or drug use? Do they smoke marijuana 2 times a day or 2 times a year? Does the other parent spend so much money on drugs or alcohol that they don't use child support money for your child? Does their habit require spending so much money that they aren't financially capable of raising your child? An infant or toddler cannot take care of themselves. If a parent is too drunk or high to feed a child or give them medicine, that's a problem. If it happens multiple times, then that's a pattern and more of a problem. And past behavior is the best predictor of future behavior. It's in the worst interests of the child to put them at risk from the parent's behavior. If the child is school-aged or a teenager, they shouldn't have to act like the head of the household because their primary custodial parent is drunk or high and incapable of taking care of things. Now we've covered 2 more best interest factors. In the next episodes, we'll discuss additional factors so you can learn what to talk about and how to put it together for your judge. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.